This is a California regulatory explainer on what's called underground regulations and the role of California's OAL. Now, California's Office of Administrative Law, or OAL, is charged with ensuring that agency and department regulations promulgated by these entities of California state executive branch are clear, necessary, legally valid, and available to the public. And OAL is responsible for reviewing proposed regular and emergency regulations by the state's more than 200 agencies, departments, boards, commissions, and bureaus that have some form of rulemaking activity. The formal rulemaking process is established by the state's APA, Administrative Procedure Act. That's found in the Government Code, and the APA sets forth the criteria by which OAL reviews all of these regulations. OAL reviews both regular and emergency rulemaking projects, as well as challenges to so-called underground regulations. Now, on the OAL website, readers can track the list of rulemaking actions submitted by OAL for review by executive branch agencies and departments. The list is updated regularly by OAL staff, and the website also contains a listing of underground regulation petitions that are under review by OAL staff. You can visit their website at www.oal.ca.gov. Now, concerning the review of alleged underground regulations, the role of OAL is specified in the California Code of Regulations in Title I, Division 1, Chapter 2. It's naturally titled Underground Regulations. Chapter 2 has several sections of interest. In Section 250A of Title I, there's the following definition of an underground regulation. It's defined by OAL by regulation to mean any guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule, including a rule governing a state agency's procedure that is a regulation as it's defined in Government Code Section 11342.600, but it has not been adopted as a regulation and filed with the Secretary of State pursuant to the APA, and is not subject to an express statutory exemption from adoption pursuant to the APA. In the California Code of Regulations, Section 260, the submission of underground regulation petitions is addressed. And Section 270 deals with the OAL review of these petitions to review an underground regulation. Section 280 describes the suspension of underground regulatory activities. And in terms of underground regulations, OAL is charged with reviewing any challenge regulatory agency actions by way of a written petition that's filed with OAL. According to OAL, it says that if a state agency issues, utilizes, enforces, or attempts to enforce a rule without following the APA when it's required to do so, this rule is called an underground regulation. And state agencies are prohibited from enforcing underground regulations. If an individual or an entity believes that a state agency or department has issued an alleged underground regulation, then the issuance can be challenged by filing a written petition with the Office of Administrative Law. If OAL accepts that petition for review, then OAL issues a determination. According to OAL, this program is informally known as its Chapter 2 unit, or CTU. Again, because OAL's regulations regarding underground regulations are found in California Code of Regulations Title I, Chapter 2, hence Chapter 2 Unit, or CTU. The OAL website provides information on underground regulations, and it describes how to submit a written petition to OAL alleging an underground regulation and requesting OAL to review that potential underground regulation. Now, OAL's review of an alleged underground regulation is limited to a three-step analysis, and the determination is whether the alleged underground regulation must be adopted as a regulation pursuant to the procedural requirements of the state APA. First, Is the policy or procedure either a rule or a standard of general application, or a modification or supplement to such a rule? Second, has the policy or procedure been adopted by the agency to either implement, interpret, or make specific the law enforced or administered by the agency or that governs the agency's procedures? If the answer to these two first questions is yes, then the challenged rule is a regulation. And then, before a determination is complete, OAL has to review the third and final step of its analysis. Has the policy or procedure been expressly exempted by statute from the requirement that it be adopted as a regulation? If the answer to this final question is yes, then the underground regulation simply didn't have to go through the APA process. However, if the answer to this last question is no, then the rule or standard being used is an underground regulation, and it cannot be enforced by the agency or used by it. Instead, if they want to use it, it must go through the formal rulemaking process pursuant to the procedural requirements specified in the APA and California's Government Code. Finally, you should be aware of Government Code Section 11340.5, Subdivision E. It provides that if an interested person has already begun litigation challenging an alleged underground regulation, then a determination issued by OAL may not be considered by the court in that pending litigation. Those challenging an alleged underground regulation should determine whether they want to pursue OAL's review of the agency activity or whether to go directly to Superior Court to challenge the alleged underground regulation.